and as well as that closing that comes in with that choice. Another way, though, that Lao became an administrative remedy that I don't think we've heard as much about today is that President Clinton issued Executive Order 13166 in the year 2000. And I think that is also an interesting way to measure and observe the impact of Lao. At least as of 2010, the Government Accounting Office administered a study to see how well this executive order had been implemented in the federal agencies. And mind you, the executive order essentially codified Lao in yet another administrative form. It required, on the one hand, that federal agencies create guidance for the recipients of their services, therefore the recipients of public funding. But it also required that the agencies themselves ensure that there is meaningful access to the services they administer. So it put the agencies themselves on the hook. And at least as of 2010, so 10 years after the initiative, the executive order issued, 22 agencies had completed the recipient guidance. 58 agencies had submitted a LEP plan, a limited English proficient plan, to explain how their agencies would ensure that meaningful access was being provided. It's hard to know what percentage of agencies that is, because it's left up to the agency to determine whether or not they fall under the mandate and which vital documents might need to be translated. But that is a far reach. 22 agencies with recipients, 58 who had submitted plans, each in different policy arenas. Okay, so I think that is one sort of powerful way to see the broad reach of Lao versus Nichols. The DOJ has kept up this pressure with a reminder letter to the agencies in 2011 and a working group that has propped up with the Assistant Attorney General's involvement in order to promote coordination among the different agencies and resource sharing as well. I see time is short, so I'll just mention that the last and maybe least direct, but most powerful sort of ripple effect, I think, of Lao is the reach of Lao to policy arenas where language access is not legally mandated, but nonetheless where there have been voluntary partnerships and cooperation that have sprouted up to promote language access. And again, these are all things where they're very much in formation. There's certainly ways to go. But I see a lot of hope in some of these examples where it is the normative impulse of Lao and not just the legal mandate of Lao that has continued the effects to move forward. So one example that I've learned about is the U.S. Department of Justice's letter to state courts who wouldn't directly fall under the mandate of Lao, but have now come ahead of federal courts in ensuring meaningful access in many cases, and meaningful language access in many cases. And so the state courts certainly are under the federal obligation, but they also have taken upon themselves to go much further than that. In addition to state courts, the guidance that's started to sprout out shows that these promises ensure access not only in the criminal court setting, where there might be a due process violation, but also in civil courts and also in administrative settings as well. So I think my hope as someone who now studies immigration law a lot is that we can continue to see the promise of Lao realize itself in places like the immigration courts, which are both administrative and civil in nature, but also have many of the due process initiatives in place. I can go on with other case studies, but I won't in respect of time. But I do think that as much as there is a long way to go, and there needs to be smart thinking about the strategies that are available in the current climate that we have, I do think there is something encouraging about realizing that the frontiers on which this work can happen have reached so far beyond the classroom and reached so far beyond the population of Chinese Americans and have moved so far beyond one particular case. This was much more than one decision, and it's had an impact that goes far beyond just one classroom.
Good afternoon. It's indeed my pleasure to be invited by Ming and Ed to be on this panel today, and I've been asked to talk about the bilingual election provisions of the Voting Rights Act. I really appreciated what Ming just shared with us to give that tie-in between Lao and the reference in the congressional deliberation back in 1975 with regards to access to the ballot for linguistic minority voters. You know, unlike our current dysfunctional congressional situation here in the United States today in 2014, back in 1975, on the heels of the Lao decision, our congressional representatives, and indeed the president at that time, President Ford, had the courage to enact the bilingual election provisions into law at a time when Asian American voters were barely a blip on the political electoral scene, and Latino voters were present, but certainly had not emerged to the state where they are today. So consequently, looking at the political environment then, they didn't really have to do it, but in fact, those congressional leaders and the president had the courage to make the bilingual election provisions into law. And what were those provisions? And simply stated, and the provisions actually have changed over time, but I'll just share with you today what are the current provisions that mandate a county or a city to provide bilingual access to linguistic minority voters. Under current law, if a county or political jurisdiction has 10,000 persons or 5% of the voting age citizen population, and if these 10,000 or 5% of the voting age population in that jurisdiction are a member of a single linguistic minority group, and this population group has a low English language literacy rate, and also do not speak English very well, then that county or political jurisdiction is obligated under the bilingual election provisions to provide language access through bilingual ballots or bilingual poll workers and other materials. So it's a fairly straightforward requirement. In 1975, when President Ford signed the bilingual election provisions into law, San Francisco was actually the only county in the United States that was required to conduct elections in an Asian language, that being Chinese. And then there are, of course, many counties that were required to provide bilingual access to Spanish-speaking citizens. And in San Francisco, the city officials had an obligation to conduct elections in both in English, Chinese, and Spanish. Now, in 1975, our election officials here locally and in the state were not actually very enlightened. They were in fact quite hostile towards this new mandate. And they did everything that they could to scuttle implementation by coming up with a lot of arguments. It was going to cost a lot of money. They didn't understand why it was necessary. And then opponents of bilingual elections made these allegations that we were going to allow non-citizens to vote, or that bilingual materials would allow community groups to mislead and unduly influence citizens who are limited English speaking in terms of how they would vote. So bilingual elections, even though it was the law, became a lightning rod for opponents against anything that might require a language other than English. And even our Secretary of State at that time, March Fong Yu, had a very weak spine. And she really raised a lot of concerns and objections. And it actually became very uncomfortable for her to raise these issues because her very close niece, Patty Fong, worked at Chinese firm for affirmative action. And Patty actually had to call out her own aunt to say, you know, you really should do this, and it is the law. So we went through a number of arguments and battles with our local registrar of voters, with the Secretary of State, and even the governor's office had some qualms about what these costs would be. And of course, many of their allegations and fears were unfounded. So with this situation, it actually became quite untenable in San Francisco because the registrar really was not moving apace with complying with the law. And because of the a lack of diligence on the part of the registrar, Chinese Affirmative Action joined with MALDEF to sue the city and county of San Francisco for not complying with the bilingual election provisions. Unfortunately, the judge at that time was not very sympathetic to our complaint, and he fairly quickly tossed out the lawsuit on its ears. So we had to constantly monitor and document how well or how not well election officials here in San Francisco were not complying with